The Supreme Court on Tuesday took up a major voting rights case out of Arizona. The issue at hand is whether two state laws violate Section 2 of the Voting Rights Act of 1965. The decision could have an impact on other election laws under consideration across the country. Natalie Brand has the latest from Washington.
The U.S. Supreme Court heard arguments by teleconference Tuesday on challenges to two Republican-backed voting laws in Arizona. One throws out ballots cast in the wrong precinct. The other restricts who can pick up absentee ballots. Democratic Party officials who raised the case argue the measures unfairly affect communities of color.
Here, what we have is a record that shows that Native Americans and Latinos in Arizona rely disproportionately on ballot collection, and white voters do not.
Arizona's Republican Attorney General Mark Brnovich argues the rules are in place to preserve the integrity of elections, not to prevent people from casting ballots.
Arizona's requirements that ballots be cast at assigned local precincts and its restrictions on ballot harvesting are appropriate election integrity measures that do not create any disparate impact on racial minorities, but serve us all equally well.
The case centers on a crucial remaining provision of the Voting Rights Act of 1965, which prohibits election practices that discriminate on the basis of race.
And it comes as state legislatures around the country debate sweeping changes to voting laws following the 2020 election.
This election was rigged.
And continued unfounded claims of widespread voting fraud. The Brennan Center for Justice says more than 40 states have introduced over 250 bills that would restrict voting access.
This is exactly why we need a strong Voting Rights Act, is to ensure that if any of those policies get passed and they're discriminatory, we have a way to stop them.
The case before the High Court will also test the new conservative majority's approach to voting rights. A decision is expected by the end of June. Natalie Brand, CBS News, Washington.
For more on this, let's bring in Kim Wehle. She is a professor of law at the University of Baltimore Law School, a school of law, rather, and the author of the book, How to Read the Constitution and Why. Kim, welcome. It's good to see you again. So let's start with some context. The Supreme Court's last major decision on the Voting Rights Act came in 2013, when the justices gutted Section 5 of the law. Give us a little background on that decision, and why was it so significant?
So, Elaine, the history of American voting is essentially a very narrow access point. Only landed white males with money could originally vote, and that was expanded, but it was still really hard, primarily for people of color, to vote. So in 1965, Congress passed the Voting Rights Act, and it had two critical provisions. It was one of the most important pieces of legislation, really, in American history, because it went right to democracy. The first provision was Section 5. That essentially said, listen, if you're a state that's sort of played some tricks on voters in the past, imposed things like literacy tests, or ask someone to recite the Constitution or the Declaration of Independence, these kinds of things as a measure to get access to the ballot, we're going to make you go through the Justice Department before you change your laws under the guise of voter integrity. And the Justice Department's going to double check whether what you're really trying to do is keep brown and black Americans, frankly, from the polls. So the Supreme Court looked at this in 2013. Multiple times the Congress basically repassed this legislation because it was so successful in giving people access to the polls. But in 2013, the court basically said, you know what, this is based on old data. It's based on data back from the 60s. We don't like this statute anymore in today's world. We think it's working too well, frankly. Ruth Bader Ginsburg said, well, just because your umbrella is keeping the rain off of you doesn't mean you get rid of your umbrella. But they basically struck down Section 5 and said, Congress, go back to the drawing board. And Congress hasn't done that. Tomorrow, the House will vote on a piece of legislation that aims to get Section 5 back in there. But what's happened is now plaintiffs are having to rely on Section 2, and that's in front of the Supreme Court today. That relies not so much on the Justice Department checking to make sure things are okay, but individual voters groups or voters have to go to courts and say, my access to the ballot, my ability to have my vote counted is restricted. And so the Supreme Court is essentially being asked to use Section 2 to do what Section 5 used to do before the Supreme Court struck it down.
So when it comes to Arizona in the case now, why are Republicans so interested in keeping these laws on the books? How does it benefit them?
Well, just like you said in the lead up to the piece, the Brennan Center for Justice has shown, 253 efforts across the country, 43 states, to make ballot access harder. The Republican Party, leading up to November, made it really clear. Listen, we want to make it harder to vote, and this is. I don't think there's any pretense around this anymore. We want to make it harder to vote because that kind of keeps the minority party, really the Republican Party, historically over many years in power. And of course, with this lie, frankly, about fraud in November, it's created some gas in the tank, so to speak, to push these laws forward. And I say lie because we know 60 different courts, 90 judges threw out lawsuits challenging November because there's no evidence of fraud. It's a moment that we all should feel good about, frankly, in American history, because thousands of regular Americans came out in a pandemic to make that election work in November. And really, the way to win elections should be on the issues, not on keeping people from the polls.
Right. And in fact, FBI Director Christopher Wray, in his testimony today, underscored that and said that there was no evidence of widespread voter fraud. Kim, conservatives hold a 6-3 majority in the Supreme Court. I know you do not have a crystal ball, but what is the likelihood that we see the justices uphold these voting restrictions in Arizona when, they decide on this case later this year?
Well, even sort of voting rights lawyers, more progressive lawyers, don't expect this court to strike down these two provisions, one of which is making it hard to have other people collect ballots on your behalf. That was shown in the case to fall disproportionately on Native American populations that don't have access to mailboxes like other people. You have to use public transportation. And the other one had to do with precincts. If you don't vote in the proper precinct, your ballot is thrown out. But in Arizona, the argument is, listen, the precincts move around. You don't, especially if you're low income, you might not have the same residence for long periods of time. And so you're trying to do your best. You cast your ballot, the ballot gets thrown out. But some would say, listen, these aren't the best cases for using Section 2 from a voting rights perspective. And frankly, the law isn't that well established by Congress in terms of what the test is. Republicans would want a very high bar, say unless you can show intentional discrimination on behalf of the legislature of Arizona, it doesn't work for you. The voting rights advocates would say, listen, there's an impact on certain minority communities. If you can show a history of discrimination, then we need to change things to make it equally accessible to the polls. I think that it's very easy for a 6-3 majority to say this is something it's not for judges to fix, it's for legislatures to fix.
So more broadly, how could the High Court's decision affect other voting measures that Republicans have proposed?
Well, I think if they say, listen, this is not a Section 2 case, there's no claim here, it certainly gives more credence or more ability for these various voter suppression laws. When I say voter suppression, harder to get to the polls, those laws to not only be passed, but also to be upheld by the courts. We've seen also in Georgia, for example, an effort to get rid of voting on a Sunday. Some would say that disproportionately falls on African-American voters who go to church on Sundays. In Arizona, another provision that basically would give state legislatures the ability to take the vote away from the popular vote and hand it to whomever the state legislature wants in a particular election. We are really seeing, Elaine, a massive backlash on voter rights through these various state legislatures. So the question isn't so much for the Supreme Court. I think the question is for the U.S. Congress. Are they going to find the votes to pass massive national legislation, which the Constitution authorizes? We've seen it. The reason you can sign up to vote at the DMV, at the Department of Motor Vehicles, is because Congress said you can do that. Congress can do more. But some would argue unless there are adjustments to the filibuster in the Senate, there's no way even a democratically controlled House and Senate will get that passed. So we're really at a moment. Are we going to go forward as a democracy by we the people, or are we going to allow essentially entrenched, powerful politicians to hang on to power by virtue of keeping us away from the polls? And I think both the Biden administration and the U.S. Congress are going to have to make some really difficult choices as to whether they want to spend their political capital on the right to vote itself.
Yeah, I mean, as you point out so eloquently, Kim, these really are questions that go at the very heart of our democracy. All right, Kim Wehle. Kim, always great to see you. Thank you.
Thanks for having me, Elaine.